Hey guys, it's Anthony Bandiero here, attorney and senior legal instructor with Blue to Gold Law Enforcement Training, bringing you the Roadside Chat. I'm joined by my very good friend and legal instructor with Blue to Gold, Zach Miller. How you doing, Zach?
Doing well. Good to see you. Let's answer some questions.
All right, let's rock this. So I just got this. I'm going to share my screen here. I just got this case here, or this. I read this article, and it's been something that's been on my mind for many years, and I want to see if you can help me analyze this. In a nutshell, what happened here is this guy named Goode. He shoots. He's a firearm possessor, and he shoots himself in a Walmart in Texas. Now, at this point in time, it doesn't seem like he's a prohibited person, and Texas has constitutional carry. So he's, even if he has no permit, he's fine to have that gun in the Walmart. But he does have an accidental discharge. He shoots himself in the knee. He's taken to the hospital. Of course, he still has his gun, and the cops seize his gun, and they do what's called a NIBIN, right? I forget the actual acronym, but it's basically a ballistic testing of the rifling and the cartridge of that case. So, and they put into a database, and there's other similar matches from crime scenes, then that will basically be traced back to his gun. Well, that's what actually happens. So the gun, the cartridge in his firearm was traced back to a cartridge found at a murder that happened sometime before. I forget exactly how long, but Goode allegedly was driving by this homeless encampment and started shooting 5 rounds into the homeless encampment and actually shot a guy in a sleeping bag. Of course, this shell casing is a key piece of evidence, and they also have some eyewitness testimony that saw a vehicle matching Goode's, but they didn't know it was his at the time. Now they do, okay? He has the gun, and he drives a very similar vehicle. The question for us, right, is what constitutional issues do we have here? So there's our friend Goode right there, okay?
All right.
What constitutional issues do you see? Now, first of all, I want you to answer this question first. Do you think that this is a search under the Jones case?
Yes. Yeah.
Okay.
I think it's unquestionably a search under the
Why?
Jones analysis because you have all the elements. So Jones requires this is the physical trespass as opposed to the expectation of privacy test. So we have a physical trespass upon the firearm where we're manipulating it and to physically test it. That's
Yep.
easy.
Okay.
It is a
And he has a
constitutionally
privacy, and he has a privacy, well, not, I'm sorry, not a privacy interest. He has a possessory interest in a firearm that he owns. It's not stolen.
It's his right. It's his effect. So therefore it's a constitutionally protected area, and
Okay.
we're doing it to gather information. So I think it meets all of the Jones prongs or
Okay.
elements. Yeah.
I
So now
agree. Okay. I agree. Now, I want you to know, just for full disclosure, there is a case, and I'll put this in the notes below. But there is a case out of Washington, a district court. So it's not an appellate court, but there is a case out of Washington where they found the judge found that this was not a Jones search. However, I've always disagreed with that case. I think the logic is faulty. I'm not a judge, so this guy's probably smarter than me, but I don't think he got Jones right, because we also have other cases that says poking tires in Texas is a search, chalking tires in Saginaw is a search, and putting your hand on the engine for engine heat out of Utah is a search. So, I think he put too much faith in the privacy argument, which does not really part of Jones. But I'll put that in there so people can compare our viewpoint with this judges in Washington. Now that we both agree that this is a search, do you think that this is lawful? What would be your argument that it is a lawful search?
So I think we could do two arguments. I don't know that one is better than the other, kind of off the cuff, but
Okay.
I think we could argue search incident to arrest if the gun was found on his well, first of all, if he was arrested, custodially arrested, as opposed to written a citation and released. I'm
Right.
I'm assuming he was taken to jail at
I'm
some
assuming
point.
too. Yeah. Right.
Okay.
Yeah. Let's assume that.
Yep. All right. So we do a custodial arrest, or we do a full search of his person, assuming he still has the gun on his person. Then that would be under the Robinson branch of search incident arrest, a categorical automatic. We get to search it for evidence that he could destroy or weapon.
Yep.
So I think it would fall under that category, and then the further analysis, I think we could probably argue that's an extension of that search incident to arrest.
Now you're not 100% sold in that argument.
No, I'm not. This is just kind of off the cuff. We know that we can do a breath test. for
DUIs,
DUI
right?
arrest. But that's
Mhm.
evidence of that crime. But
Correct.
we also, and then I just thought of this one too, and I mentioned it to you, the Maryland versus King. This is the DNA buccal swab where we arrest this guy for a serious offense, and they do a warrantless, non-consensual buccal swab, and the Supreme Court says that was good. That was justified under the booking procedure, routine
Right.
booking procedure,
It's
because
like
of
almost like taking fingerprints, I guess, even though it's a little.
exactly photograph, yeah, fingerprints, because of they talk about the value of the DNA database to solving future crimes. So we could put that into the same thing with the Niven analysis.
Yep.
I'd say this is a serious offense.
I
So,
think so.
maybe the routine booking procedure exception might
Yeah,
apply.
and look, that I think those are viable arguments. If I was the prosecutor and if this issue came up in the case, that's what I would argue. I will tell you that I don't know if that's going to work because I feel like, okay, if I'm arrested for if I'm arrested for some kind of crime and I'm taken to jail, whether it's disorderly conduct or shooting myself in the knee like this guy did, and they took my clothes, which is and they did some kind of analysis on my clothes, and it came back there was DNA from a murder victim on my clothes. I just don't know how that would be like a search incident to arrest, and I think that's But now my clothes weren't necessarily involved in shooting myself in the knee, right? The gun was. However, how does that how does no this knife and this forensic analysis of this firearm have any evidentiary value at all at all to this case? This is not going to come in. It's not
Right.
probative at all. It has no weight
Right.
whatsoever for the jury or the judge to consider about whether or not, I mean, unless it's a contested issue that the bullet came from that gun, but that's not going to be at
Yeah.
all.
It's kind of far-fetched to
It's
think that's,
far-fetched.
yeah.
Correct. And
Yeah.
they're also, and the other thing, Zach, and I think, this is probably the bigger issue, is that there are a lot of agencies that are doing these forensic analysis, as a matter of routine. Does that concern you?
Absolutely. Even for non-criminal, we encounter the gun for non-criminal reasons. Yeah, and we're just kind of routinely sending them off because that's what the ATF wants us to do, to
That's what the
build
ATF,
their
they want to build
database.
that database.
Yeah, yeah, and so yeah, so we're taking guns for safekeeping because somebody's been involuntarily committed for mental health treatment, or maybe somebody, a family member has died and they've got
Right.
guns, they don't know what to do with them, so we're going to hold on to them for a while. Yeah, and we're
A person had to have standing to contest that search. But
sure.
I'll tell you a classic one that I worry about is a guy gets a DUI. Okay, he has a gun in a car, and in some states like Nevada, it's not actually illegal per se to have a gun in your car. It's not in Nevada; it has to be in your immediate control. So if you're intoxicated and have the gun in your waistband, that's another violation. But if the gun is in a backpack in the back seat, that's not a violation. That's not against the law in Nevada because it's not in your immediate control even though you're intoxicated. It's not constructive possession, it's immediate possession, which is closer to actual possession, right? So
Right.
the point I'm bringing up is that you'll have cops that have that kind of situation where they have a gun and it's not part of any crime, and they're going to take the gun for safekeeping, which is fine. We know that's fine, but then they run it through forensics, and that gun will come back to, let's say, a murder like this, and I think we have a huge problem.
Yeah, I think so too. Yeah.
So
I can't think of a situation like that what we could justify the Jones, because we've established it's a search. So
we've
now we
established
have
it
to
as
do
a
our
search. Now,
yeah.
one of the things in that Washington case, and I think we'll end off on this because we want to make these kind of quick for our YouTube viewers, is that the judge said another reason he liked it and he upheld it was because it's part of an inventory. In other words, that forensic analysis will definitely be solid evidence that that's the gun that he gets back when he gets out of jail.
Oh wow.
But yet it had a serial number. It was not stolen. He was not a prohibited person. And I got to tell you, I'm calling straight up BS on that. If my car gets towed, the cops are not doing a forensic analysis on the paint, a spectrum analysis to make sure that I get that exact Honda Accord back,
Right.
So that seems like a far fetch. You'd agree?
And that one, that's wild. Yeah, I can't believe it. You would actually put that in, actually write that down in an
Oh,
opinion.
it's in the opinion. And
Yeah.
I think that,
Yeah.
I think that helped prove to me, Zach, that this judge is a results-oriented judge. There are judges, especially I did tell you what state it was, Washington State.
You did.
And it was also on the West Coast, right? The district, the West Coast district. So there's a good chance that based on this case, this is a very anti-gun judge. and just wants to get, and I want bad guys to go to jail too, but I want them to do it in the right way, right? So the point is that's where we're at. It's a breaking case. We'll put this case in the notes below, and you guys have to read the case, follow it. And I'm really interested to see if these arguments come up, Zach.
Absolutely. Yeah. And what state was this? This was Texas, right?
Texas, correct.
Yeah. Okay. Yeah.
And so Texas don't play, when it comes to guns,
Yeah.
they usually, get it right, when it comes to these gun laws. So, the poking the tire case, and what I mean by that, a trooper in Texas was poking a tire to, for various reasons, but to see if there's something in the tire. It happened to be packed with narcotics, and the prosecution argued that there was no search there. But the Fifth Circuit said actually that was a search because you were touching it with the intent to get information. So if they're saying poking tires in Texas is a search, I think this is a search. So we're going to have to see how this pans out, my friend. I'm glad you joined me. I just want to get kind of a quick video to let people know that we're watching this case, and we're going to see how it pans out. All right.
Sounds good.
Thanks, guys. I'll see you next time.
Yeah.